Morning. Your Honor, I'm also, first of all, I'm not most qualified to argue some of the boards because, as you may recall, I wasn't even here for the early portion of the trial when some of those matters came to the forefront. What I would suggest we do, since we were also told by the prosecution that they have a whole series of slides that were specially prepared for summation that are not in evidence already, and we have to review those as well before the summation begins. What I would ask is for the Court's indulgence to give Mr. Shapiro and Mr. Cochran just 5 minutes to look at the that timeline board and the so-called abuse board, which they could do very, very quickly, and at the same time we could look at the slides.
Well, that's why we started at 8 o'clock this morning, Counsel.
I know, and we were here on that, Your Honor. There were some technical glitches, but one of the things we expected to see at 8 o'clock this morning also was their slideshow. We've yet to have that pre-screened for us. So I'm simply asking that we have that done.
Right,
and while we're doing that...
We're going to take up the boards first, Counsel.
All right.
All right. First one, evidence from the Bronco.
Well, the problem we have with the boards, which are referred to as evidence from the Bronco, evidence at Rockingham, and evidence at Bundy, allegedly connecting Mr. Simpson to those three scenes, is that the Court made a very explicit ruling early on in this case that the people cannot use the term match to refer to draw a connection or nexus between hair and fiber evidence and individuals. That you, in fact, had to instruct Ms. Clark repeatedly when she violated that rule to refrain from using the word match and stick to consistent with.
So the bottom line of your objection is that you object to the wording on the board regarding the hair and the fiber.
That's correct. Not regarding the blood, because the Court drew the distinction there, but regarding the hair and fiber.
All right.
That although they're allowed to argue, they're not allowed to misstate the facts. And you set very strong parameters as to what the facts were with regard to hair and fiber.
All right. That pertains to the evidence from Bundy, the evidence at Rockingham, and evidence from the Bronco boards, all
That's
three
right.
boards.
There was another board, which was a timeline board, and just from my initial review, and again, I would need the help of Mr. Cochran and Mr. Shapiro on this, is that there was a suggestion that Cato heard 3 knocks between 10:51 and 10:52, whereas his testimony, both on direct and cross, is 10:40 to 10:45. And there is no testimony of 10:51 to 10:52 in the record, and they have no business asserting facts on a board which don't exist in the record. So at least as to that statement of fact in the board, we would object to that and ask that it be changed. I think also you should bear in mind, Your Honor, that I believe that the prosecution has little cards and has the technical ability to make substitutions and changes depending on your rulings this morning, because they indicated that as to another time they were going to make a change and put a card on it. But again, I would like my co-counsel to just have just a 2-minute opportunity to quickly look at that board as well, because there were a lot of different times on it, and I will be the first to admit that I don't have that kind of expert familiarity with every time suggested on there, and we would just like to be able to check it.
All right. Any response to the objections regarding the boards? Ms. Clark, good morning.
Yes, Your Honor. I mean, if it even needs a response. I plan to argue, as the Court is aware, that Mr. Diedrich can testify to what he saw through a microscope, and that can only be deemed consistent. But when we consider all of the evidence in the case, we know that it is his hair. And this is argument. That's the reasonable inference to be drawn. At this point, I should not be confined to saying it's only consistent, because I'm not just talking about Mr. Diedrich's opinion or conclusion based solely on the microscopic comparison. I'll make that very clear to the jury. There's not going to be any doubt in anybody's mind, and I'm not going to be saying Mr. Diedrich said it was a match. I'm not going to say that either. Mr. Diedrich said it was consistent. That's all he could say. That's all he knew. But when we look at all of the evidence, we know it's his hair. That's entirely permissible, in fact, mandatory argument in a case like this. So I don't think the Court needs to hear that much more from me on that. With respect to the timeline, this is the problem with having, lawyers argue that haven't been here. On the timeline thing, Cato said that he heard the thumps, and 2 to 3 minutes later he walked out of his room. Alan Park said that he was on the phone with his boss and hung up within 30 seconds of that, of seeing Cato and the defendant out in the yard. Cato on the side yard, the defendant in the driveway. We have his cell phone records that indicate that that phone call was completed at 10:55 something. It's on the board, Your Honor, in any case. So I time it by that. We have a very, very accurate way of determining when Cato went out to the side yard and when he heard the thumps based on that. Is there anything else?
Those are the two objections to the boards. Any response, Mr. Neufeld?
Judge, I believe that the prosecutor's argument is simply that that's when Parks saw the two of them. But the phone records and his testimony, both on direct and cross, is that it could have been 10:40, it could have been as late as 10:42. That's the window. They just enlarged it by 10 minutes, and there's absolutely no testimony to support that. It's the phone records even aren't consistent with that. And we can pull out in 10 seconds if you want the portions of the transcript so it's crystal clear. But that number 1052 just comes out of thin air and is not supported by the facts. And I think if you just give us a minute, we'll pull it for you.
No, I recollect that there is some imprecision in the times, and the only times that we have are dated, are timestamps by the phone records. I agree with you there. However, I think that the prosecution has a rational basis to make that argument, and they make that argument if it's illogical or if it doesn't make sense to the jury, they make that argument at their peril. But since they can extrapolate, so to speak, from the testimony, I think they're entitled to make that argument. All right, the other objections will be overruled with the following modification. Ms. Clark, I'm concerned that the hair and fiber, to say that it's the defendant's hair or fiber from the Bronco when we know that the testimony is that it's consistent with, I think a labeling should be that it is consistent with. Sure.
I would understand the court's concern if it was an issue of misrepresenting to the jury what the scientific testimony was. I'm sure the court can appreciate that when everything is put together. And that's the argument. These boards are a summation. These boards are not just based on Mr. Diedrich's testimony. And I will not let the jury be misled in that regard for 1 second. The purpose of these boards is to put it all together to say when you consider everything, you know this is his hair. That's the Bronco fiber. I'm going to make it clear. I'm not going to leave any doubt in anyone's mind what Mr. Diedrich said. He could only say this. But on this board, I'm asking you to consider all of the evidence, and there's a wealth of it. And when you put it all together, you know it's his hair. And that's the purpose of closing argument, is to put it all together. So I understand the court's concern, but I can assure the court 100% that the jury will not be misled by my argument, and the boards are closing argument boards. They're not going back in the jury room. I'm very clear about that. And so I'm going to tell the jury that. This is based on all of the evidence, not just Mr. Diedrich. And I intend to make that very clear.
The problem is the boards themselves.
Your Honor, I don't think the court invited Mr. Neufeld to stand.
No, I was still having a discussion with Ms. Clark, Mr. Neufeld.
So
I see we're in fighting moods today.
It's argument. But in any case, Your Honor, the purpose of the board is to collate everything. And if I have to start fragmenting it again, I understood for testimony. And you know, I have no disagreement with the court's concern during testimony of saying exactly what the witness was saying. But now it's argument, and it's time to put it together.
All right, Mr. Neufeld, any brief response?
Yes, Your Honor. There are other boards where they refer to letters and other items of evidence are, in fact, statements of the actual record in this case. This is the one instance where they have it on a board that is not an accurate statement of the record in this case. It is distortion, it is misleading, and it is a board suggesting that that is in fact the evidence, and that's not the evidence. And they can modify that board. They can change the wording in it to reflect the state of the evidence, just as they have on the other boards. And it's actually disingenuous to suggest that, whereas there are other boards are accurate statements of the record, but this board I'll single out and I'll explain to the jury that I don't mean this to be a statement of the evidence, I just mean this to be argument. That in itself is misleading because it sets these boards apart from all the other boards they intend to use in their closing argument. It just isn't fair.
All right, thank you. All right, the objections to be overruled subject to modification during the course of counsel's argument, if it's not accurately argued. All right, how about the other exhibits? I just said it. You have it real time. All right, how about the other exhibits? Yes. How many do you have, Mr. Fairlow?
Approximately 30 to 35.
Let's see them. Mr. Fairlow, if you're going to have any remains displayed again, would you let me know?
Yes, Your Honor. The next line, I recommend you cut the feet.
Go back one. Cochran.
Morning, Your Honor.
Morning, counsel.
Your Honor, with regard to this, the first thing I'd like to point out is that the court had given orders with regard to the time these graphics were to be displayed to us, and we had people here this morning at 8 o'clock. It said 8 o'clock this morning. We're now seeing them at about 9:20 thereafter, so they're more than an hour and 20 minutes later. I point that out because of the fact that Mr. Harris came with our information regarding the clips we wanted to use, and he misunderstood the time. He had them in plenty of time. He always gets here at 8:30. Got here apparently somewhere between 9 and 10, as I understand it. And the court,
After 10.
I thought it was around before 10, but anyway, he said he's going to pollute. This is an hour and 20 minutes. We're just now seeing these. They went through very fast, and the court saw them, so I won't belabor this, but I want to point that out at the beginning. They should be precluded if we're to be precluded. If we're going to be able to use our clips, which we have here, it's the same thing. Your order, even if it's misunderstood. Theirs weren't ready. Ours is ready. It was a misunderstanding by Mr. Harris. But the point I wanted to make was that, for instance, on these boards and looking through them very quickly, and they went very quickly, this is the problem right before argument when they do this. They talk about a Bruno Magli shoe print, and they talk about the defendant's Bruno Magli's, I believe, at one point. There's no showing that Mr. Simpson purchased or bought any Bruno Magli's in this case. They have something on the defendant that did not go to his children. His children were brought to him. I mean, this is the most misleading kind of argument. If they want to use this, many of these things they're using at their own peril. I am warning them they're using it at their own peril. But the defendant did not go to his children. This photograph, I don't know the point of this photograph, this kind of time sequence photograph, kind of in a map or puzzle kind of fashion of Mr. Simpson. This idea of rejection by Paula, there's no evidence of rejection by Paula. It's testimony that Paula was at the Mirage being paid for by Michael Bolton, I believe, but there was no rejection by Paula. Using Cato to set up an alibi. I mean, this is just specious. In this, they use at one point the term consistent with, which is what you said they can do. That further highlights when she stands up and says, it's the defendant or the defendant's hair. I mean, that's misleading to this jury. This jury's not going to fall for this. They show the photographs of the officers. Risky never testified here in uniform. They have a photograph of him in uniform. I mean, so that what they're doing here, first they're an hour and 20 minutes late, beyond your order. They're tremendously misleading, and we need actually more time to actually look at these to see. This is just jotting down as we went through these very, very quickly. And it seems to me this is totally unfair and contrary to the spirit of what you were talking about. Now, I contrast that with the video clips. The video clips, Your Honor, are exactly what happened in this courtroom.
I'm not listening to that argument, counsel.
All right, well, it's still the same thing. Well, then they get precluded then. If you're not listening to that argument, then under the same thing in fairness and an equal playing field, then these things get precluded. They weren't here on time, and so here now we're facing the situation. If you don't want to hear the argument regarding Mr. Harris yesterday, then it seems to me this should be precluded. I mean, clearly. You said 8 o'clock, it was clear.
Any other objections?
Well, it's really difficult, Your Honor. We saw them so fast for the first time. We really need to see them again. I need a little more time with them, quite frankly. That's all that I was able to jot down at that point as we looked at them together for the first time, an hour and 20 minutes later.
All right. Why weren't these things here at 8 o'clock?
They were. They were. Jonathan was here. He was here with all of the clips and the slides. They weren't ready. They were here, and we were ready to go. That's the answer. That's the answer. They don't have an excuse for this one. We were here. We were ready. They were not. That's it. With respect to the points on the slides, however, Your Honor, I've never had to preview my closing argument in any trial in my life. Those points on the slides are my argument. Now, unless defense counsel is going to be fair about this and give me their closing argument, I'll review it, and I'll tell Mr. Cochran what I think is fair for him to argue, too. Okay? If, as he says, the jury's quote-unquote not going to fall for that, then he shouldn't be concerned. The jury won't fall for that. I think that the jury's not going to fall for their stuff. I think the jury's going to fall for reason and logic, and that's what this is. But I don't have to make that argument now. The court's aware of these arguments. But those points up there are reasonable inferences to be drawn from the evidence. If the jury doesn't agree, if the jury thinks they're unreasonable inferences, the jury knows what to do, and they will do it. And
what about the in the triggering events board that you have there, rejection by Paula Barbieri. What's the basis for that?
During the day, I'll just trace it from the afternoon. This is based on the defendant's cell phone records. We have a phone call to Nicole at 2:30 in the afternoon, lasting for 4 minutes. Immediately after that phone call, we have 2 calls to Paula Barbieri, which were unanswered. As you recall, we had testimony from Kathleen Delaney. I think that's her last name. She was general counsel for the Mirage, and she testified to the fact that Paula had checked in to the Mirage on June the 12th at 1:59 p.m. So at the time that the defendant was trying to call her, she was already in Las Vegas at the Mirage, a guest of Michael Bolton. We also know that earlier in the morning or the previous day, Paula had asked to go to the recital with him, and he had told her no, that he was going to keep it a family event. We have our theory about what he intended in telling Paula not to go to the recital, which we intend to argue at the appropriate time. In any case, when he showed up at the recital, he was clearly, as the witnesses have testified, in a very unusual mood, glowering, spaced out, as Candace put it, simmering, I'm reminded, and whatever transpired in the phone call with Nicole at 2:30 in the afternoon clearly had something to do with that mood, in addition to the fact that when he went to the recital and the Mezzaluna date was made, he was not included, and he had already told Paula not to come to the recital. So essentially, and then he tries to reach Paula again later that night at 10:03, calling her twice when he was in the Bronco. Couldn't reach her at those times either. She was not there. So we know she was in Las Vegas. And I think that was the last straw for him. He was abandoned by Nicole. He was abandoned by Paula. And that's why we're here.
How about the Bruno Magli indication that this was his shoe?
Which,
One of the boards indicates the Bruno Magli shoe was the defendant's.
can we pull it up again so I can see, Your Honor? Much.
Let me see the next slide.
Is that what you meant, Your Honor?
No.
Next one?
I think the one that has to do with shoe print in the Bronco.
Okay. Yeah.
All right,
Yeah.
it says bloody Bruno Magli shoe print on driver's side carpet.
Yes, Mr. Boziak testified that there were characteristics in the print on the carpet that were consistent with the Bruno Magli shoe print. Would you like me to pull up the testimony? Okay. Can we call upstairs?
This is a statement of fact.
Wait. Mr. Cochran's arguing this, counsel.
The only reason is he wasn't here earlier this morning. I thought I could just give the report as single.
Counsel, that was an indication to sit down.
I'm typing up the request right now, Your Honor.
Mr. Fairlow, what time did you have this laser disc here?
I had the Laserdisc here at 8 o'clock. I did a barcode check to make sure everything was correct. 2 or 3 of my barcodes were off, so I went back up to reprint so I could show them in the correct order. At that point, I came down, I believe it was a little bit around 9 o'clock.
When was that thing actually prepared?
I finished it up last night, at about 4 o'clock in the morning. I was still dropping slides to laser at 3 o'clock last night, and I was in the office barcode until about 4 o'clock.
I'm waiting for the testimony.
Oh.
Yeah, it's going to take a few minutes. Is there anything else you'd like me to respond to?
It's the only 2 issues I've heard raised. Mr. Wooden, are we close to finding this?
It's going to take a few minutes to get this. Is there anything else we can handle? Or I won't get to that part of my argument for a while, so we can start. And then I can make sure I get that to the court before we get to that point. It's going to be about 10 minutes.
Why is that?
Because
we can tell you what he said. We have it. We know what he said. He didn't say that. That's why they're never going to find it. There'll be 10 minutes and 10 hours. They will not find it.
well, if they have it, let's see it.
Do you have it?
But he'll pull it up in just a minute. We know what he said. Said he could not say that with Bruno Magritte.
Please.
Watch.
All right, Your Honor, I think it's 32751, and I'll just try to read this. 32751? 5051, okay. I could get any of the features in this enhanced impression to correspond with a silver sole, such as I had with the other comparisons that I made. And I was not able to take an overlay and actually reconstruct the exact position of that shoe to the point where I could say it was absolutely the silver design, and even go further and say it was the same. There just wasn't enough detail. And of course, it is not representing the normal design of the case, but it is just wherever there happened to be some blood up in the grooves and wherever the carpeting had to go up, it just randomly whipped down the. So this would be in the negative area, in the negative areas of the shoes, or the areas in the grooves, so to speak.
Your Honor.
Your Honor, I think that's they will never find it. It doesn't, took 10 seconds. He can't say that, and they're still playing games, Your Honor, talking about they couldn't find it. And we found it right away. May I respond further to Your Honor?
No, Ms. Clark was in the process of telling me what the transcript says.
Yes, Your Honor. What the court needs to do is see the entire testimony. Counsel has only read, of course, a small snippet from an entire section of testimony. And my recollection, and I'm certain that I'm right about this, is that he testified, as I indicated to you previously, that there were features consistent with Bruno Magritte's shoe print.
Well,
and that's what I said before. And it is in here, and I need time to find it.
match on the board?
Yes.
Further transfer pages, let me just give the court an indication. Counsel left off at the portion where he read, or the areas in the groove, so to speak. And then the testimony was, yeah, I did notice that there was this area here which could possibly have been a border of the shoe. And there also is some little, what I call squiggles or little S shapes, which might represent the curved areas between the design elements. But they weren't clear enough or reliable enough to make any kind of a positive determination. And then can you point out the areas? And no, the upshot of his, there's more testimony on this, but the upshot of the testimony was, okay, and now he's referring to the actual carpet, and he said, okay, this area here was the area that I referred to that might be the border of the shoe, and this area down here where it changes direction, kind of like an S, is an example of that possible, the negative area of the shoe. And then can you take the rubber shoe, and that was the exemplar that he had, Your Honor, and describe for us how it is that that is possibly consistent with the sole of the Silga? Yes, well, I don't know how well this can be seen with the light, but if you follow the grooves between the design elements, they change direction. So there is gentle curves between those design elements. And that would be the area that would be, still might be some blood in it at that point, back down the driveway, that far from the actual crime scene. And these little changes of directions that you can see down here, as well as this border, and you really can't see any of them clear enough to make an overlay, but you can see something that suggests that. But there's just not enough detail to absolutely say that that is representative of the Silga sole. Okay, were you going to point out a couple of other of these design elements that were consistent with this sole? No, I think that these in here probably show it as well as any. And actually there isn't enough clarity throughout this whole thing to really point to it and say positively that is what it represents, but rather you are seeing a change of direction, and that is what you would expect if there was some blood here and the carpet tuffed up.
Ms. Clark, when you anticipate getting to this exhibit or this demonstration slide?
Let me see. That's why, we can, I mean, I think that the testimony does clearly indicate he's saying it is consistent. He's not making a positive determination because there's not enough clarity for him to absolutely positively say it's a Bruno Magli. We are making inferences, Your Honor, because we have Bruno Magli shoe prints going down the walkway and the bloody shoe print with features like it on the driver's side of the carpet. I think it's only a reasonable inference that it is the Bruno Magli shoe. It's not only a reasonable inference, it's an obvious inference. So what he said was it was consistent with, but he would not make a positive determination.
All right, thank you.
May I respond now?
Yes, two issues, Mr. Cochran, specifically responding to the two objections that you made, the triggering events issue and the Bruno Magli issue that we just finished discussing, and the second issue being an opportunity to see all of these.
Thank you. Let me take the second issue first. The court asked Ms. Clark when would she get this in her argument. She should never get to this in her argument. It's the exact same thing. This court has prided itself on being fair, I think, to both sides, or trying to be fair to both sides. Yesterday you precluded us from something that everybody knows about because it's something that happened during the courtroom, and we were only to give actually the text passages, the quotes, not even view and show and tell, which we're prepared to do, which we worked all night to do. In this instance, what Mr. Neufeld was trying to tell you, Your Honor, that at 10 minutes to 9 he spoke to you and told you they had not shown him this show and tell at that point, because Mr. Fertlow was not back down here. It didn't work at that point. There was a glitch. So it was, we said, an hour and 20 minutes after your order. So under that reasoning, I mean, this is a real easy one. They are precluded from doing this. If we take those kind of positions, it has to be for both sides, not just for the defense.
Well, Mr. Cochran, on the 22nd, late in the day, Ms. Chapman asked for an extension.
Yes.
I said yes until 9 a.m.
Yes.
All right. 9 a.m. came and went. Nobody showed up. At which point, at 9:30, I issued that order.
May I be heard on that?
So there were two chances, two opportunities.
Your Honor, it's something that's important. We asked for the other extension, and let's make clear what we're talking about here. What you'd ask us to do was to provide by 9 o'clock yesterday with a list of the items we wanted to do. Not even the items, because that takes an awful lot of work. Mr. Harris misunderstood that. Mr. Harris is always here by 8:30. Certainly, Mr. Harris didn't do that intentionally. He would never do that. He's always here every day. He's been here from Florida for a year and a half, and certainly he would be here on time. But the point is this, Your Honor, if I might just say this, if you allow me. Mr. Harris not getting here or being a half hour, an hour late on just the actual quotes, that should not inure to the detriment of O.J. Simpson. That's unfair. And so what should happen, if you want to sanction Mr. Harris or sanction us, then do that, but not Mr. Simpson. Now, let's put it in perspective here. The reason, this is far different. This is actual text that we need to see so the jury, the 14 people back there, don't have to spend this time. You said 8 o'clock. We had people here at 8 o'clock. They weren't ready at 8 o'clock. Ms. Clark again has been caught. They weren't ready at 8 o'clock. At 9:20 they were ready, just like she makes this statement here about the bloody Bruno Magli shoe print. You know, sometimes we have to have some credibility in this courtroom. So those are the facts, Your Honor. So I know you said you didn't want to hear this, but you're a wise man, and you have been fair in the past. If you look at this, well, how can we look at O.J. Simpson and say because Howard Harris didn't get a text down here, that everybody knows what these clips are, it's actually the trial testimony, that O.J. Simpson should suffer from that? Mr. Harris is very sorry about that, if he got a chance to talk to you about it. But that's just not fair, Your Honor, under the circumstances. Now, we have a situation here where they come down. They don't come at 8 o'clock. Neufeld tells you at 10 of 9 we haven't seen it. At 9 o'clock when he comes back, we still don't see it. We have to ask to see it, and it's 9:20. And you can now see why we don't get a chance to see it, because it has all these things on here. Now, that moves me to the other point you asked me to discuss, the bloody Bruno Magli shoe print on driver's side carpet. Now, Judge, she can argue all she wants. The evidence does not show that. That's a lie. The evidence doesn't show that. She can talk about reasonable inferences, which she would like to hope, but this just shows the desperation of the prosecution. At this 11th hour, they would try these tricks. And they're tricks, Judge. These are nothing but tricks. It's not going to work, but I don't think we can be part of this at this 11th hour. So, to be fair, this has to be precluded. This has to be kept out because they didn't have it here at 8 o'clock. We didn't get a chance to see it. We're prejudiced by this, even as we're arguing now. There are other things that went by so fast, I'm not totally clear on all the things that were there. I happened to pick up bloody Bruno Magli shoe print because I knew that wasn't true. But the other thing that I think you allowed me to talk about is this whole issue of Paula Barberi. I mean, that is the rankest kind of speculation. Paula Barberi stands by this man's side to this day. There's no indication there was ever any rejection. In fact, quite the contrary. They'd made plans for later that week. I mean, it's just the evidence. It's replete with the fact that she was totally supportive. And the testimony, I think, of the young lady, Carol Connor, on the Saturday night, June 11th, when O.J. Simpson takes the pictures with the elderly women at the $25,000 plate dinner. They were absolutely lovey-dovey on Friday until Paula went to a prayer meeting. I mean, it's all to the contrary. This is their fantasy, their whole case. We should have known when the ship thing came up. This is all about their dreams. And it's not going to work, Judge, but we can't be part of that. So this is unfair. And it just seems to me that they are precluded. Now, we're not saying, I would ask Your Honor to consider this, but under your ruling yesterday, they're precluded. I mean, quite simply, it wasn't shown, and this is far more different than just telling you generally what we expected to show in clips, things that you've already seen during the course of this trial. May I have a second here? And I'm reminded by my colleague, there's a far difference. Yesterday, what we're going to give you is the page and line number of things we wanted to show. And you also made it very clear, and that's why you see Mr. John Whitney here. We could not show the face of, say, the defendant or the lawyer asking the questions. So in going through all this, we had to black all that out, and that took a lot of work, as I said. But there was no prejudice to them. And I trust not to Your Honor, because it was a question of what had happened in this courtroom. We're talking about a search for truth. This is a lawyer's interpretation of what they would have hoped the evidence would be. There's much more prejudice to us an hour and 20 minutes later when she's about to stand up and argue, for them to show us this in this rapid-fire discussion. We're talking about prejudice, and it's prejudice to Mr. O.J. Simpson, Your Honor. And so that I would say to Your Honor two things. These should be precluded.
What's the people's position on the videotape issue?
May I add another page to the Bruno Magli issue, Your Honor?
No, I'm not interested. I've heard enough on that.
There's a final conclusion that he makes on it.
I recollect, counsel. I have my notes.
Okay, on the videos. Thought the court
Mr.
ruled
Cochran is arguing a sophisticated version of tit for tat.
that we be precluded from my argument.
Yep.
I don't see that that is tit for tat, Your Honor. They wanted to use, the court made a very specific ruling. The court did not say counsel is required to submit their closing argument to the opposing counsel for editing ahead of time. Court ruled that if we wanted to use video clips, they had to be, or I thought it was just the defense, but that if video clips were to be used by the defense, they had to be submitted to the court by a time certain, and that if they weren't, they wouldn't be allowed. Isn't that a little different than what I'm allowed to argue to the jury? And we're talking substance here, because all those are the words that I intend to argue. We're not talking about a slide, involving a picture of something. We're not talking about videotape, because the use of videotapes in argument is a very novel thing. So understandably, the court was concerned that it be allowed to preview what counsel wanted to use, because it is an avant-garde kind of thing to do. I don't know if it's ever been done before. And the court needed to assure itself that what was done was appropriate ahead of time. But arguing reasonable inferences from the record is something that had been done for hundreds of years, Your Honor. I'm doing nothing different. That's all I'm doing, is making it easier for the jury to see, just like we did in the old days when we had an easel and we'd get up there and write all the reasons why the defendant was guilty. Okay, so now we have this whiz-bang stuff, and I can do it on a screen, but that's the only difference. I have a witness that says it's consistent with this, but I can't positively say. I draw reasonable inferences based on all of the evidence and tell the jury, but we know it is. Now, is that something new and different that a prosecutor does? I'm not doing anything different. I'm just using a screen instead of an easel to do what we've been doing for hundreds of years. So this is not tit for tat, Your Honor. Counsel's so scared, he's saying, don't let her argue. Don't let her draw reasonable inferences. Don't let her pull this together for the jury. That's what we have here. I'm drawing inferences from the evidence, and I'm arguing the evidence. He wants to use something novel that the court wanted to safeguard. I understand that. Mr. Fairtlow was down here at 8 o'clock. Sherry Lewis was down here at 8 o'clock. They weren't ready. They were looking at the boards. Peter Neufeld had broken his glasses. They weren't ready to see anything. We were here.
That's contrary to what Mr. Fairlow has just said, Your Honor. And Ms. Clark has not answered.
To fix a few barcodes, but if they had been ready to sit here and watch it at 8 o'clock, he would have shown them what we had.
These are officers of the court. They were ready. That's why they were here, Your Honor.
Let me finish.
Wait,
Mr. Neufeld.
wait. Argument's over. I've heard enough. Thank you very much. It's been entertaining as usual. All right, the defense is entitled to see these, since they're going to be used during the course of argument prior to their use. We'll take a 20-minute recess to allow that to occur. Mr. Fairtlow was, in fact, here this morning at 8:05, because I did come out and see him seated back there, and he was playing with barcodes. We did look at the charts that were physically here, and I did use members of my staff to go down and get crazy glue for Mr. Neufeld to fix his glasses, and that was what was occupying us for the most part. Previous ruling stands regarding videotapes. The court finds that as far as the argument is concerned, there are inferences. What a prosecutor is allowed to do is to discuss the evidence and then draw reasonable or plausible inferences from that. I agree that perhaps some of these may not be logical, but it is argument.
Is that videotape on both sides, Your Honor?
Videotapes on both sides is precluded.
The court, may I say one last thing in that regard?
No. That's the end of that argument. All right, we'll take 20 minutes to show them the exhibits.
If we have objections, do we bring those to your attention?
Counsel, it's argument. I've seen them all. Show them. All right, 20 minutes. To preview. No, just look. Have you finished looking at them? That's my question. zip through that one, Mr. Harris. All right, Mr. Cochran, any specific objections?
All right, the court's already ruling your argument, but I could just look at them. I'd just like to make a general objection, if I might. These slides are totally misleading. There's a whole list of things. I won't even bother the court's time now. They're totally misleading. And to allow this jury to hear this, it just shows the prosecution's desperation. But we could point out chapter and verse, but it's not going to do any good. So I thought that we would, I would just register a general objection to this. I think it's totally outrageous. The other thing I'd like to point out to the court is that we have some graphics which are not precluded, and of course we have evidence that's items that are in evidence which we can still show during the course of this trial. Because of the fact they weren't ready this morning, they've not seen ours, so I'm going to ask that we be able to do that before we start our case. Plus, we will obviously now be responding to these lies on these boards and try to tell this jury some measure of truth. So am I correct? We can do that also?
As I noted, one uses these things at one's peril.
Yes, you did say that, Your Honor. So we'll be doing that, and I'd like before counsel, before we begin our case, to, if the court wants us to, we'll review it or not, but we're ready. If they want to go with this now, you've noted my objection.
Noted.
Let's get it on.
Thank you, sir. All right.
If I could just indicate this, they have shown us one board, Your Honor. One defense board is the thermometer involving reasonable doubt, that standard. I just want to lodge an objection to that now. We can argue it before the defense argues.
We'll get there eventually. All right. Deputy Trier, let's have the jurors, please.